All right, Ms. Natale reports that other counsel says he's logging into Zoom right now. Good morning.
Good morning, Your Honor.
And for the record, please, your appearance.
Yes, Your Honor, this is Adrian Middleton on behalf of Mr. Benjamin Rase.
Go ahead, sir. You filed a number of things after the trial had commenced.
Yes, Your Honor. Just as stated in my motion, Your Honor, I felt compelled to notify the court of what was occurring in the parties. As stated in my motions, the family hired me last week late. There was an issue communicating with the client at the jail. When you go to create a visitor account, they have you upload your ID, and I did so in my photo, and I followed the directions specifically, but they did not approve it because instead of ID, what they meant was, even though it states your ID, they meant my bar card. So it came back as not approved. I was told by the family the trial had been continued. I filed immediately. Once I learned this information that it was set for a bench trial yesterday, I learned that last night at about 11 o'clock, Your Honor. And I had to sit there and say, well, do I not interfere? Do I put on the record? I felt I had to, as counsel, put on the record just because it would eventually be addressed either in a motion for new trial or some other future proceeding possibly. And so I did so, Your Honor. At this point in time, what I'd be asking, because he did hire me last week, I was paid, I was retained. I did that same day reach out to the facility to get a visitation. It was my mistaken belief that the trial had been continued. I had no understanding that it would be reset for yesterday. I did see that it was quickly reset on the docket. I quickly filed last night, or drafted everything I could last night until I could not work anymore. I filed everything this morning as early as I could. And so, Your Honor, I would ask if we can continue the trial. I don't know. I had very limited communication with my client last night. He did call me over phone line, and I had to restrict the conversation just to the procedure of where we are. But I did file a motion to continue requesting 30 days. I understand if evidence has been commenced that I may be restricted to that, but I felt compelled to notify the court as opposed to remain silent and then file something after everything had concluded. I felt that would be, one, dishonest, and two, not being a zealous advocate, and it would be unfair to the parties that are already effectively in the middle of trying this case with their efforts, time, and resources that they've already put into this case. But, Your Honor, it did result entirely from a misunderstanding that was compounded by a denial for me to communicate with the client. I did speak with the jail staff this morning. They've been very responsive. I am now approved. I can speak with them. I can drive over today. I don't want the court to think that I'm not serious about the fact there's a time issue, and I'm not going to sit around, and I'm not going to request an extensive amount of period of time to prepare for the case. I'm familiar with the charges. I'm familiar with what I know, and I understand the minimum mandatories and things that apply to this case. But I'm not prepared for a bench trial today, and I don't know any of the prior proceedings that have occurred and anything that's been discussed on the record. So candidly, Your Honor, that's where we are. But I did file that motion to continue. I did file a notice of appearance, request for substitution, and I did want to make that known to the court and would be requesting that relief. I don't know if there's been a plea. I'm sure defense counsel knows those things, and I'm not impugning defense counsel at all whatsoever. I know that there were some motions filed for Nelson, and I think the client has a right to choose counsel. That doesn't mean that I take any position in regards to counsel's representation up to this point at all. But those are the motions that I filed, Your Honor, and those are the reasons why I filed them.
Does the state wish to be heard on any of these issues?
If I could just put some things on the record, Your Honor.
Yes, Ms. Clisson, you may.
In all candor of the court, Your Honor, I have not read every filing that Mr. Middleton has filed because these filings were not received until right before court was scheduled to start this morning. But I would like to lay the record and indicate that this case has been pending for 3 years. These filings are untimely. They were filed on the second day of trial, and it leads the state to believe that this is merely a delay tactic. If it's not a delay tactic, it seems like an intentional way to manipulate some type of appellate issue further down the road. No notice of hearing was filed, or notice of appearance was filed until this morning. If Mr. Middleton was retained on July 22nd, like he says he was, why wasn't a notice of appearance filed then? It wasn't. Why isn't he here today? If Mr. Middleton was so serious about being retained and truly indicating that he is going to represent Mr. Rase, why isn't he here? If the court were to grant a mistrial or a continuance in this case, I think the record needs to be clear as to what prejudice the state would receive as a result of that. The state has presented, as of right now, the state has presented 13 out of 15 witnesses. One witness who came in after having ACL surgery last week. One witness was from Tallahassee who drove in We also have present here today, the last two witnesses, the medical examiner who drove here from Pensacola, and we have the surviving victim who's in a wheelchair who flew in from North Carolina yesterday and was put up in a hotel last night, and he's ready to testify. So the state would clearly be prejudiced if the court were to grant a mistrial or a continuance. We also...
So if I could, let's go ahead. Sorry, I thought you were finished.
Double jeopardy has already attached at the commencement of this trial. There's no legal basis for a mistrial or a continuance at this point. Mr. Middleton can view the line items that are listed on the clerk's page. If he doesn't have access to the actual attachments, anyone can log in and see this was set for a bench trial on July 27th of 2026. Mr. Middleton hasn't reached out to me. My name and my email is publicly available on the clerk's page associated with this case. I have never, until this morning, spoken with Mr. Middleton regarding this case.
If I may respond.
If I may finish, Mr. Middleton.
Sure, I didn't know you're
I
finished.
heard Mr. Middleton indicate that he was denied access. That's via video. Our jails allow for in-person visits. So if Mr. Middleton was retained on the 22nd, he could have very easily gone to the jail to speak with Mr. Racer. I don't have any indication that he's spoken with Mr. Racer at any point except for what he mentioned last night. So the jail would let him come and visit and meet with Mr. Racer if he would have attempted, but he didn't. Also, just some of the statements that I've read in the filings contain just blatantly untrue statements, such as statements and assumptions, I would say, such as the defense has never been afforded a continuance, such as his Nelson hearings haven't been heard, when in fact the court heard the most recent Nelson hearing at pretrial on July 13th. That hearing that was heard. So a lot of these statements that he's listed in these filings are just not factual. Also, we've sat through 1 day of trial so far with 13 witnesses. Mr. Racer has had competent counsel. That counsel has been present throughout depositions of this case, and he's been present through all of the pretrial matters as well as through the first day of trial. He's been attentive, and he's been the counsel of record. And there's no indication that Mr. Middleton has any type of specific, he's not a DUI expert attorney. That's my understanding. He does not have a specific niche in this field. Your Honor, I would ask that the court deny these continuances and the motion for mistrial. And just to lay the record, explaining why I believe the court has discretion in this matter. However, I believe the factors that we should look at is what's before us, and the state would be extremely prejudiced. The defendant's been afforded his due process rights as of now, and I do think that this is, it's a delay tactic, and the state is ready to finish the trial today.
So, Your Honor, I'm just going to respond to the allegations about me and one other. I candidly did not know at all that it had been reset because the communication I had, because I had not had communication with the client directly from his sister, was that the trial had been canceled. We received payment. We quickly filed, when I found out that this was occurring in the middle of the night last night, I filed everything. As far as, that's a very short turnaround period of time. I was operating under the belief the trial had been canceled, is what I was told. It was set for a jury trial, then canceled, and immediately, apparently, it was set for a bench trial on Monday. And so, opposing counsel is correct. I don't know enough about what's going on to make totally factual statements, and that's why she hedged her language. I'm only going off the docket. That's why I said in my motions very specific. It's my understanding, which I even think I stated could be accurate and accurate. I don't know. I didn't make factual assertions. It's only what I could go off because I can't see anything other than the docket because I'm not accessed into my portal yet because of the notice of appearance being filed recently. And so I can't see any of the back end stuff that's going on with the court. So I have to make assumptions. And I hedge that by saying I'm not certain, and my language indicates that. So I'm not trying to perpetrate any fraud upon the court. I just felt that based on what I knew, now that I know it, I needed to make it known. It's not a tactic to delay. If I just sat quietly and didn't do anything, knowing that I had been retained last week prior to the commencement of the bench trial and just sat on that, and I think that would be unethical, number one. I can take the ire of the court and I can take the ire of opposing counsel, but I'm not going to sit and basically lie and sit there quietly knowing that I'd been retained now that I figured out what was occurring. And it happened strictly from just a miscommunication between his sister when I was hired very expeditiously, and I tried to reach out immediately to speak with the client so I could get an understanding now that what I'd been told is trial was canceled. When I did look at the docket, it looked canceled. We did not pick up that it had been set for a bench trial for Monday, and that's on me, but I still don't want to, I do not want to effectively lie through omission by not knowing now what I know and knowing what the family had told me. Once that was explained to me, and I had every intention of going to see him this week when I had time. Today was the first day after about 1 that if I wanted to go see him, I could. And I would be more than happy to, but I felt that it would be worse if I did not explain what had occurred, the misunderstanding. But I fully understand the state's position. I fully understand why they're objecting. I understand exactly what they mean in regards to the witness issues, but I felt I had to raise this isse because I was retained, and I believe counsel. I think Mr. Razor had said that he had retained an attorney. I filed as soon as I figured out what was going on. I accept responsibility for as much as it should be levied to me, but under the facts, it was very difficult to understand that it was being reset for a bench trial. It was very confusing. I tried to communicate with him immediately. I was denied because of some language in how they want an ID versus a bar card. They didn't know that I was an attorney per se, is what I'm getting back from the jail. Now they know, and they've approved me. But again, I'm not going to, my job is just to file my motions and do what I think is appropriate under the circumstances, which, again, I did not know there was a bench trial set. Having found that out, I took the appropriate action. I thought as a zealous advocate, as a criminal defense attorney, but I also understand the state's position. But I assure you, on my part, as an attorney, was not to delay because I did not have the information accurately. And as soon as I found out the accurate information, I made every attempt to disclose that to all parties because I feel it would have come up down the road anyways. And so, Your Honor, I'm just filing my motions. My arguments are made. Opposing counsel is correct about certain docket issues. I don't know everything that occurred because I wasn't there. And that's why I used the language that I used. It's not assertive and accusational, it's inquisitory and more concerned because I don't know. And that's it, Your Honor.
I've reviewed briefly the things that you filed simply because I wasn't aware of their filing until this morning when I reviewed the progress docket. In May of this year, I made it abundantly clear at the cycle in May that the case was going to be tried this trial cycle, period. There would be no further continuances. At that time, Mr. Razor had said he intended to try and hire counsel, and I instructed him that if he did so, there would be no continuances based upon him hiring private counsel. The case was going to trial. It's 3 years old. It needs to go to trial. I reiterated that again on the next hearing date, which was about a week later in May. We restated that again in this trial cycle in our preliminary procedural hearings, and again made certain that the case was set for trial. It was then at the second pass at that the then the question of a bench versus a jury trial, and was set for the bench trial. What I believe you saw as a cancel was jury trial review, which is basically a trial management conference on the Friday before jury selection. It has never been canceled. It has remained set for trial the whole time. And I instructed Mr. Razor each time that he indicated he was going to hire counsel, that there would be no continuances based upon retaining counsel. I gave him very specific instructions that if he retained counsel, he needed to instruct counsel that they needed to be prepared for trial, because there would be no further continuances based upon the number of times that it had been continued and the case needed to be disposed of because of its age. Mr. Razor did, in fact, say something yesterday morning, and my JA reached out to your office and left a message at your office the very first thing yesterday morning, and never received a communication back from you regarding whether you did or did not represent Mr. Razor. We then proceeded with swearing the first witness and commencing the trial. Based upon those circumstances, the court respectfully denies your motions, and the trial will proceed.
Okay, thank you, Your Honor.
Now, you're welcome to remain here based upon your agreement with Mr. Razor's family if you wish to observe the trial. And without any question, you're welcome to do that. Your participation will be limited. If you wish to consult with counsel present in the courtroom and other arrangements, I'll give that opportunity for you, but the case will proceed. We have 2 witnesses left, including one of the alleged victims who's traveled to testify, and the medical examiner. That's the last evidence. And then Mr. Koch, who's been representing the defendant. Oh, and one last thing. I understand you couldn't see all of the documents because you weren't yet associated, as the clerk calls it, with the file. I think when you are associated, you'll see that each one of the requests for Nelson has been disposed of in open court on the minute sheets. And if you were to look at if you were to get the records of those proceedings, you will see that I've informed Mr. Razor that his claims of for Nelson were insufficient for me to discharge his counsel and appoint new counsel at the state's expense, but he had the right to retain counsel at his own expense if he desired to do so. So with that said, we'll proceed with this at this point in time. Now, Mr. Koch, who's been representing him, has indicated that the defendant has not yet made a decision of whether he wishes to or wishes not to testify in the case. And if you wish, then I can make arrangements, or Mr. Koch can, if you wish to be involved in assisting Mr. Razor in that decision, but that would be up to Mr. Koch and his supervision of how they wish to manage that. Okay? But with that, you're welcome to remain here during the presentation of the balance of the state's evidence, if you so desire.
I would do that, Your Honor. I think that would be appropriate. As you stated, my interaction will be minimal if there's any need for me to interact at all. Again, I just felt I needed to file the motions that I filed based on the misunderstanding and what had occurred. Now, with Your Honor's explanation, I do understand much more, and I will go back as soon as I get access and review the things that Your Honor's raised, which I'm certain is correct. But again, I had to do what I thought was best at the time based on the limited information that I had and the misunderstanding that occurred. And so I will remain here.
And I understand that, Mr. Middleton. You know, in some respects, our electronic world has made the world worse, because in the old days, you'd have had to drive over here and actually look at the paper file and make your decision. Now with the electronics, we expect to be able to look at it straight away, and when it doesn't work straight away, then it puts us in a worse pickle than having to tell our prospective client, I'm sorry, I can't get there and look at the file soon enough. I'm not going to make the decision until I can, so I understand that. I worked for a man who joined the bar in 1929, and his rant used to be about the copy machine, and he hated the copy machine. everybody gets a copy and nobody looks at the copies until the week before trial. In the old days, you had to come to my office and we'd had a cup of coffee and we'd talk over the evidence and we resolve cases. And I can't imagine what Old Man Hall would be saying about emails and text messages, and we've passed through the fax machine era. So I'm not sure that we're actually in a better place with electronics. But with all that said, let's take a short comfort break. Let's all get our feet back under. Mr. Koch, if you want to share, if Mr. Middleton, you want to share a direct phone number with Mr. Koch right now and make that link, assuming that's okay with you, Mr. Koch, so that you can chat with him and make that connection. I'm pretty sure you don't want to do that in the public courtroom right now, but that way you can make the connection with him for the benefit of your clients, for your client.
Rhonda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main. Jack.
He's been here. He ain't left. No flag. Because when I go through like this whole process, it's like the conditioner, city
Thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
You're gonna have to stand to come point it up.
Just
Stop resisting. I want to hear a good stop resisting. I want a clear one now. I don't want to be like, hey, I want a clear order. I bet you will. Very well.
All rise. Court back in session.
Please be seated. All right, so you asked about how we could publish while they were there, and I did a quick test. If one of you will decide who's going to, where's Mr. Middleton? If whoever's going to be publishing will go ahead and log on to my Zoom connection, do not join with audio. Then when you're ready to publish, you'll share your screen and we'll publish through the Zoom connection. And I'll put the spotlight on your connection, and that way the documents will appear through the Zoom connection. But if you join by audio, then we're all going to wail from the feedback.
Okay.
All right? You on board?
I'll let you know. As long as they're not published through the media that's in the courtroom, it will be autopsy photos.
Okay. Okay. All right. Very good. And if that doesn't work, then we'll just have to, but I think it will. I've done that in chambers, well, excuse me, in the small courtrooms. I think this will function okay. It's once again, you got to be clear you can't join with audio or we'll get feedback.
Your Honor, I'm not sure if I have your Zoom information.
All right, and it's just it's my PMI. I think Charles has it. Just remember, Mr. Gomez, do not join with audio.
I made sure that my audio and my video are off for that part.
Yeah, but that, just turning your audio off when it gives you the option, do not join with audio, because just muting will not fix that,
No pressure.
okay?
Got that? Good.
I think so.
All right, now, you're gonna have to turn, go ahead and share your screen and let's do a test. All right. Are you able to see that, Mr. Middleton? Just give me a thumbs up if you are.
Your Honor, I'm able to see it, and I'll mute and go off camera so in case I'm distracted.
Okay. And so what I'm going to do, Mr. Gomez, is I'm going to, let's do that one more time. And what I'm going to do is I'm going to, now this will lock you, so you'll be, no matter if anyone talks, it'll show. So when we get ready to share, you just let me know, and that will lock that screen right there for you, so it won't flop back and forth when other people are talking. Does that make sense?
Yes, Your Honor.
So now we can just go ahead and do that right now when you, and good deal.
Okay.
Perfect. So once you turn your video back on, then that screen will be available for you, and you'll be able to share anytime you're ready. Okay, were you able to see it over there as well, Mr. Koch, on your
Yes.
screen?
Yes, on the big screen, yes, sir.
Okay, all right,
Thank
very
you.
good. All right, so, state your next witness.
Dr. Lorraine Lopez.
Dr. Lorraine Lopez, please.
While she's approaching, may I approach and grab the pointer that Your Honor has?
Yes,
Thank you.
our decidedly high-tech device. All right, and if you'd remain standing and raise your right hand for me, please. Madam Clerk, will you swear the witness?
Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Please be seated and direct your voice to the microphone you see there in front of you. Speak clearly and distinctly so we can all hear and understand you. Also, there's a court reporter in the back of the courthouse taking this all down, so it's important you're able to make a good record. Is that okay?
Yes, Your Honor.
And if one of these lawyers objects, stop speaking immediately until you receive an instruction how to proceed. Is that all right?
Yes, Your Honor.
Okay, thank you. Ms. Glisson, you may inquire.
Good morning. Can you please state and spell your first and last name for the record?
Good morning. My name is Lorraine Lopez Morel. That's LORRAINE LOPEZ MORELL.
Where are you currently employed?
At the District 1 Medical Examiner's Office in Pensacola.
How long have you been employed there?
4 years.
What's your position there?
Associate Medical Examiner.
Does the Medical Examiner's Office in Pensacola service the county of Okaloosa?
Yes.
Are you licensed to practice medicine in the state of Florida?
Yes.
How long have you held a medical license?
Since 2014.
And you stated you're currently a medical examiner?
Yes.
Were you a medical examiner also back around August of 2023?
Yes.
Briefly discuss with us the training and education that you have received in order to become a medical examiner.
I completed my undergraduate studies at Michigan State University, a bachelor's in science and physiology. I then went on to my medical degree at Columbia University in New York City. I then completed a 4-year program of residency in anatomic and clinical pathology. And I finally then went on to a forensic pathology fellowship.
You mentioned clinical pathology. Tell us what that is.
Clinical pathology is the branch of pathology that encompasses all of the specialties that deal with laboratories. For example, the director of the blood bank is a pathologist, the clinical labs, microbiology labs, everything in the hospital is directed by a pathologist.
And you also indicated you have a degree in physiology?
Yes, a bachelor's in
What is
science.
physiology?
Physiology is the study of all of the mechanisms in the body, how the body performs. And
did you conduct a residency?
Yes.
How long was your residency?
4 years.
And what about a fellowship?
Yes.
How long was that?
1 year.
Okay. What is forensic pathology?
Forensic pathology is the subspecialty of pathology that deals with pathology as it relates to medicine. Forensic pathologists are tasked with determining the cause and manner of death in sudden and unexpected deaths.
And you've been trained and received education in that field as well?
Yes.
Are you board certified in any fields of medicine?
Yes.
What does it mean to be board certified?
You complete an ACGME accredited residency program or fellowship program. So basically, accreditation council of graduate medical education has to approve of a program. Then that experience qualifies you to take a board exam, usually a day or 2 days, depending on the specialty. And that passing of that board exam certifies you.
What specialties are you board certified in?
Anatomic, clinical, and forensic pathology.
What does anatomic mean?
Anatomic is the branch of pathology that deals with autopsy medicine and surgical pathology. So any tissue that's taken out of the body and is looked at under the microscope.
How long have you been board certified in those fields?
Since 2017.
Okay. After you finished your many years of education, did you immediately begin your career as a medical examiner?
Yes.
Where were you first employed after you finished your schooling?
At the Monroe County Medical Examiner's Office in Rochester, New York.
What was your title there?
Also Associate Medical Examiner.
How long were you a medical examiner in Rochester?
Almost 3 years.
So after those 3 years, did you transfer to another city or state?
Yes, I did.
Okay, and where were you employed at that time?
At the Institute of Forensic Sciences in Puerto Rico.
In Puerto Rico, okay. And what was your title there?
Associate Medical Examiner 2.
During your employment, both in Puerto Rico and Rochester, were you conducting autopsies on a daily basis?
Yes.
How long were you employed there in Puerto Rico?
Almost 3 years as well.
Okay. And after Puerto Rico, where did your career take you next?
I moved here to Pensacola.
Okay, and what year did you start working at the medical examiner's office in Pensacola?
2022.
Okay. Dr. Lopez, in your career, approximately how many autopsies have you performed?
More than 3,000.
Okay. Approximately how many of those autopsies would you say involved victims of car crashes?
About a quarter of them.
Have you ever testified in court in the field of forensic pathology?
Yes.
Approximately how many times?
More than 40 times.
As part of your expertise and the expert testimony that you've given, those more than 40 times, how many of those times included giving your opinion as to cause and manner of death?
Every time.
Okay. Your Honor, I now tender this witness to be a person who's qualified to testify as an expert in the field of forensic pathology.
Do you wish to voir dire?
No, Your Honor.
Court finds the witness is based upon her education, training, and experience qualified to express her testimony in the form of an opinion on the subject matters tendered.
Thank you. Dr. Lopez, did you perform an autopsy on a person identified to be Demetrius Thomas on August 23rd of 2023?
Yes.
Whenever a body is received at your morgue, is an identification photo taken of that person?
Yes.
Your Honor, if I may approach what's already been introduced into evidence as State's Exhibit 14.
Granted.
Thank you. Dr. Lopez, this photograph's already been introduced in evidence as State's 14. If you could please examine that photograph. Do you recognize that photograph?
Yes.
Is that photograph, does that depict a photo that was taken after receipt of Mr. Thomas's body?
Yes.
And is this a photograph that would be one of the identification photos that are taken?
Yes.
And this is the person that you conducted an autopsy on?
Yes.
What methods or procedures do you use when conducting an autopsy?
A combination of all of my training and experience.
So kind of walk us through when you conducted Mr. Thomas's autopsy, what are just the general steps that you take once the body is received?
Once the body is received, photographs are taken by our forensic photographer before anything is touched. Then full body x-rays are taken. Afterwards, I perform my external exam, in which I document any identifying features such as hair color, eye color, teeth, scars, tattoos, and any injuries. Then I proceed to the internal exam, which involves making an incision from shoulder to shoulder, which meets in the center of the chest and extends down into the pelvis in order to examine the internal organs for any natural disease or injury. The same is done with the head. We make an incision behind the ear, over the top of the head in order to avoid deforming the face in any way, and remove the brain in order to examine it for any injuries.
And you mentioned that as a normal part of the autopsy, photographs and x-rays are taken, is that right?
Yes.
I have, let me show defense counsel what's been pre-marked as State's 14, if I may approach the witness, Your Honor.
Granted.
Oh, I've been instructed that this is State's 15, Your Honor.
15?
Not 14, yes.
All right. Mr. Cacci on board?
Yes, Your Honor. Thank you.
These will need to be adjusted. To be 16.
And you've previewed this?
Yes, this is exhibit, no objection, Your Honor.
All right. All right, 15 is admitted.
Well, I have no objection
Oh, I'm sorry.
to approaching, yes, Your Honor.
Okay, I apologize.
Dr. Lopez, I'm showing you what's been marked as State's 15 for identification. Do you recognize this item?
Yes.
How do you recognize it?
I reviewed it and signed it with my name and dated it as well.
What is on this item?
Photos that were taken during the course of the autopsy examination by our forensic photographer.
Did the photos that you reviewed on this disc accurately depict the autopsy photos, or the way Mr. Demetrius' body was presented to you, and photos taken during the autopsy on August 23rd?
Yes.
Do these photos appear to be edited or altered in any way?
No.
Your Honor, at this time, I would offer what's been pre-marked as State's 15 into evidence as State's 15.
No objection, Your Honor.
It's admitted.
Thank you. And Dr. Lopez, you discussed how you perform an autopsy and how you performed an autopsy on Mr. Thomas, the general steps. Those methods and procedures that you use when conducting an autopsy, are those generally accepted within the relevant scientific community?
Yes.
Permission to publish State's 15, Your Honor?
Granted. Now, This is going to appear on the big screen, so please, our video, if you be careful about that. Okay. All right. Thank you very much. Observe the privacy of the victim and the victim's family, please.
And Your Honor, may I publish from the desk? May I speak?
Granted.
Thank you. No, I'll let you share it.
The audio, this might be an issue, Mr. Gomez. You're probably going to have to connect to audio to play the audio. So I'm going to do my best by working the feedback here. Hold on just a second.
Your Honor, these are just photos that were.
Are there just photos, there's no audio?
Yes, Your Honor.
Okay, all right, go ahead.
Yeah. And Dr. Lopez, on States 15, I'm going to publish what's been marked as photo 7520. When Mr. Thomas's body arrived at the morgue, was his body delivered to you in a body bag?
Yes.
And is this what this photo depicts?
This depicts the seal that the body bag has. On every case, we place a metal seal that if it's tampered with, it would show evidence of that.
Okay. And was it sealed properly?
Yes.
Okay. Do you recall what Mr. Thomas was wearing when he was received at your morgue?
He was wearing blue pants and socks.
Now publishing 7527, does this accurately depict Mr. Thomas's body? One moment. Does this accurately depict the way Mr. Thomas's body was after it was removed from the body bag?
Yes.
Okay. In photo 7528, does this depict his lower body? Look at this.
Yes.
Thank you. Okay. When you received Mr. Thomas's body at the morgue, was there still anything connected to his body that had indicated that life-saving attempts had been made?
Yes.
What was attached?
Defibrillator pads and an endotracheal tube, which is a tube that goes in the airway to help a person breathe.
Okay. And were any personal items taken from Mr. Thomas's body and kept placed in evidence?
Yes, a set of car keys.
Okay. And I'm showing you photo 7541. Does this depict the car keys that were removed from his body?
Yes.
Did you weigh Mr. Thomas when he was brought in?
Yes.
How much did he weigh?
148.5 pounds.
What was his height?
5'3".
What was his age?
52.
Let's talk about the external injuries that you observed and noted on Mr. Thomas's body. Let's start with the first photo of the external injuries. Photo 7605. Can you describe to us what you're seeing here? He's-
Yes, this is the top of the left shoulder and the left upper arm. You can see the left ear on the right side of the photograph, and our unique case number identifier in the bottom with a scale. The injuries that I documented that are shown in this photo include scrapes of the left upper arm or abrasions. They're punctate or dot-like and irregular on the left upper arm, and there's also a band-like abrasion over the top of his shoulder, and you can see the edge of the abrasion on the front of the neck, extending down towards the right chest.
Are you able to identify what caused those injuries?
The arm abrasions, I'm not. However, the abrasion to the neck, extending from the left side downward towards the right, is very typical of a seatbelt injury.
In your medical opinion, are these injuries fresh?
Yes.
How do you know that?
There's no sign of healing.
Go to the next photo. Okay, we're publishing 7604. Can you explain to the court what we are seeing here?
This is the front of the left arm, showing the same abrasions as the previous photo, just a different angle. Multiple dot-like, irregular scrapes of the skin on the left upper arm.
Photo 7608. What are you documenting in this photo?
This is the laceration I mentioned in the head section under evidence of injury. The curvilinear line or tear in the skin in the middle bottom of the photo, in the back of the scalp. It is a tear of the skin in the scalp.
Okay, 7611, which is the photo we're publishing. Is this a close-up of that same injury?
Yes.
Are you able to determine if this injury was a fresh injury?
It was.
How?
There's no sign of healing.
Were there any other external injuries that you noted to be on Mr. Thomas's body?
There were some abrasions of the left knee, and that is all.
Okay. Did you next examine the internal injuries of Mr. Thomas?
Yes.
Okay. Okay. Publishing 7720. I want to start with the head of Mr. Thomas. Did you examine his head?
Yes.
Okay. What are we seeing in this picture?
This is the left side of the head with the skin of the scalp reflected forward. As I described in my previous autopsy procedure, the incision is behind the left ear. You can see the skin of the scalp is reflected forward over the top of the head. You can see right next to the label and the case number is a darker red area that represents a bruise or a contusion that corresponds to the laceration that we saw in the previous photos.
Dr. Lopez, because we don't have a laser pointer that works from where you're sitting, would you feel comfortable stepping down and using this old school pointer here, just so we can indicate the injuries that you're talking about? Permission? Your Honor.
Granted.
If you could just point to those injuries that you were indicating.
The darker red area here next to the label is a bruise or a contusion, meaning that there was a direct impact to that area, causing red blood cells to leave blood vessels.
Is that on the left side of the head?
Yes.
Your Honor, may this witness remain at the...
Granted.
Dr. Lopez, if you need a refresher, your memory with your notes, we can retrieve those for you. Photo 7726, what are we seeing here?
This is the brain after the top of the skull is removed. We're seeing subarachnoid hemorrhages on the right side of the brain, this dark red area, the back of the brain on the right side, and this dark red area on the middle of the brain on the right side. This is the parietal lobe, this is the occipital lobe. Those represent areas of contusion or bruising to the brain.
You mentioned bruising. Is subneuratoid hemorrhage bruising?
Yes.
Okay. And is that injury fatal on its own?
If not treated, it could be.
What causes that type of hemorrhage?
Usually blunt force, although it can happen due to stroke or other diseases.
And how many areas can we see of bleeding that's in the brain right now?
Two. On the right side, relatively small areas on the occipital and the back of the brain, and one of the parietal.
Thank you. Okay. Was Mr. Thomas's torso also examined?
Yes.
I want to talk about the injuries that you observed within his torso. Before you go in and examine the injuries that you see, do you kind of take an overall photo of the insides of the body once the torso is opened? Let's look at photo 7678. What are we seeing here?
This is an overall photo of the chest before the ribs have been removed to show any injuries to the chest.
Okay. From this photo, are we able to see any obvious injury to the torso?
Yes.
Can you point those out?
We can see some hemorrhage representing a possible rib fracture on the left side of the rib cage.
Okay. 7680, what are we seeing here?
This is the side of the rib cage on the left. You can see some hemorrhage in the muscle overlying one of the ribs on the left side.
How does that type of injury occur?
Blunt force injury.
Are you able to see any of his ribs from this photograph?
Yes.
What are you observing in relation to the ribs?
In this photo, the ribs, I can't see any rib fractures yet. However, I'm concerned that these areas of hemorrhage represent possible rib fractures.
The hemorrhage in the center of that photograph, is that injury fatal on its own?
Not likely.
Okay, thanks. Let's look at photo 7681. What's being documented in this photograph?
This is a close-up of the front of the rib cage on the right side. You can see the stomach here, and this is the bottom of the rib cage on the right side. This area of dark red and this gap here in the rib represents a fracture of the rib.
When a rib is fractured, what are the complications that can be caused by that?
Well, the rib cage functions as a sort of bellows, a structural element to maintain the lungs expanded so that they can imbibe air and expel it. If there's any compromise to that structure, such as rib fracture, then the functioning of the lungs is going to be compromised as well, depending on the severity.
Do you recall approximately how many broken or fractured ribs Mr. Thomas had?
There were 18, I think.
18?
Yes.
How many ribs does a typical 52-year-old male have?
They have 24.
So 18 out of 24 ribs broken or fractured?
Well, they were all 9 ribs on the left side. They were broken on the front and on the back.
What does all of the ribs being broken on the left side indicate to you as a medical examiner?
That the blunt force injury came from that direction, and it was a significant amount of blunt force.
Okay, next. Photo 7682. Is that a closer up view of the injury you were just discussing?
Yes.
Okay. Is there anything else you would like to add to this photograph that you observed? Okay. Photo 7723. Okay. Could you please point out the injuries that you identified and that we see in this photograph?
This is the front of the body without the chest plate on the front. So you can see the heart in the upper center of the photograph, the lungs on either side, the liver. The heart has a tear or laceration in the left ventricle, which is the ventricle that pumps blood into the rest of the body.
Is a tear in the heart fatal in this home?
Yes.
Yes. Okay, thank you. Go ahead.
And you can see collections of blood in the body cavities, the chest, both sides, the pleural cavities around the lungs.
The collections of blood that you're pointing to, are those the dark red images or the dark red that we see within the body?
Yes.
What causes internal hemorrhaging like that?
A variety of reasons. Any compromise of vessels can leak into the chest, whether it be the lung or the ribs. But in this case, it's the rib fractures that are causing. Each rib has a set of vessels and nerves attached to it underneath. So when a rib fracture occurs, if it's severe enough, if it completely tears the rib, that those vessels and those nerves also get torn and begin to bleed into the chest cavity.
Okay. And I know you've identified a lot of the organs that we see here, but could you just go ahead and identify the other organs where they're located?
Certainly. This is the stomach. The stomach is not where it should be.
What do you mean by that stomach's not where it should be?
The location of the stomach was identified to be partially in the left chest. Normally the stomach is in the abdominal cavity, held there by the diaphragm, the muscle that helps us breathe. And in this case, the diaphragm tore or was lacerated, and a part of the stomach ruptured or migrated, moved into the left chest cavity. You can see it very clearly on the x-ray as well, but the top part of the stomach should not be above the liver. It should not be in the chest.
And you mentioned a torn diaphragm. If a diaphragm tears, will the person be able to breathe?
They will have a hard time.
Can the lungs expand properly if the diaphragm tears?
Well, the diaphragm has two sides. If one side of the diaphragm tears, the other can still function. But one torn, it severely compromises the ability of the person to breathe.
And which sides were torn of Mr. Thomas?
The left.
Can a torn diaphragm cause significant bleeding?
Yes.
Photo 7724. What injuries can you identify in this photograph?
This is a close-up of the front of the body with the organs in situ or in their original locations. You can see more clearly the laceration to the heart or the tear in the heart, and the collections of blood in the body cavities, as well as the stomach protruding into the left chest.
You indicated earlier that tear to the heart would be fatal. Do you have an opinion as to when the tear occurred, how quickly someone would die due to that injury alone?
Case reports on stabbings of individuals that have sustained similar injuries to the heart vary. The most extreme example I can think of is a gentleman who ran for about 45 minutes after receiving a similar injury, but that's an extreme example. Most cases, when you can't pump blood into the rest of your body, it is a rapid decline.
Were you able to examine Mr. Thomas's lungs?
Yes.
What were the condition of his lungs?
There were multiple bruises on the left side. Otherwise, they were normal.
Were you able to tell, to determine how the bruising occurred of the lungs?
Likely because of the rib fractures.
Okay, what do we see in here in 7725?
This is a close-up of the heart, showing the tear in the heart, in the apex of the heart. If you looked at this, you could see inside of the heart. So it was completely through and through the wall of the muscle of the ventricle.
Okay. All right. And the last photograph I want to publish, Dr. Lopez, is going to be numbered It's going to be Thomas 2 JPG. Does this indicate a photograph of the x-ray that was taken of Mr. Thomas's body?
Yes.
Okay. What does this x-ray show us?
It shows us a good summary of all of his injuries.
Let's start with the torso injuries.
First, you can see when comparing it to the right side, you can see that the left rib cage is significantly compromised. You can see ribs poking outward towards the soft tissue, and they're very obviously fractured. You can also see a very obvious fracture of the left femur, the left leg bone. There are also fractures of the pelvis. The right pubic rami are fractured, and there's an open book fracture of separation of the pubic symphysis that's in the front of the hip bone.
What is a fracture, Dr. Lopez?
A fracture?
Yes, ma'am.
It is a breaking of a bone.
What can cause a fracture?
Usually blunt force.
Okay. And did you note any other injuries? I interrupted you. I'm so sorry. I wanted to ask you before I forgot. You can continue.
No, lastly, the chest is most impressive. The heart, which should be in the center towards the left, is actually shifted to the right. You can see the airway or the trachea tracing downward towards the right side, which is not where it should be, and it should be in the center. The left chest does not show lung tissue in this space, representing that the left lung is collapsed. And you can see the air bubble from the stomach protruding into the left chest due to the diaphragm laceration. This bubble here should not be in the left chest, should be in the abdomen.
The organs that you just mentioned that should be either in the center or on the left of Mr. Thomas's body that were actually pushed to the right, how would those organs be pushed to the right of his body?
As I explained earlier, the chest, the rib cage acts as bellows. So there's a very a tight seal. So if that seal is maintained on one side, but it is compromised with the other, that the seal in the intact side is going to pull all of the organs towards it because that is the nature of suction. The heart, the trachea, the lung, the other lung, everything's going to be pulled over towards where there's a seal and the other side is filling with blood and air.
Thank you. Are there any other injuries that you need to point out with the x-ray?
No.
And Your Honor, may this witness be seated?
Granted.
Dr. Lopez, these injuries all within Mr. Thomas's body, would those injuries be consistent with Mr. Thomas sitting in the driver's side of a vehicle and an impact of another vehicle hitting him on the left side of his body?
Yes.
If Mr. Thomas received all of those injuries that you've just discussed, if you received those simultaneously, would you expect Mr. Thomas to have died immediately?
I would expect rapid decline, yes.
What, kind of give us an idea what you mean rapid?
Seconds to minutes.
And during those seconds to minutes, if he did live for seconds or minutes, would he have had difficulty breathing?
Extreme difficulty, yes.
Would he have been in extreme pain?
Yes.
After you conduct your full autopsy, as a medical examiner, is it one of your jobs to also determine the cause and manner of death?
Yes.
Can you explain to us what the difference is?
Yes. The cause of death is the series of medical diagnoses that lead to the death, including the root cause. So diagnoses like myocardial infarction, heart attack, or stab wound or gunshot wound. The manner of death, on the other hand, is a choice between 5 check boxes on the death certificate. It is natural, undetermined, accident, homicide, and suicide.
Okay. So the cause of death, is that what physically killed him?
Correct.
That's what that means. And the manner of death, just explaining how the death happened?
Yes.
Okay. Were you able to reach a conclusion and were you able to form an opinion as to what Mr. Thomas's cause of death was?
Yes.
And what was that?
Multiple blunt force injuries.
Were you able to determine Mr. Thomas's manner of death?
Yes.
What is that?
Accident.
Accident.
Yes.
An accident, is that a medical conclusion or a legal conclusion?
A medical conclusion.
Are most car crashes deemed to be an accident?
Yes.
Do you hold your opinions and conclusions as to cause and manner of death for Mr. Thomas to a degree of medical scientific certainty?
Yes.
Okay. Were there any other injuries that you had observed on Mr. Thomas that you noted that I did not ask you about?
No.
Okay, thank you. I have no other questions, Your Honor.
Mr. Koch.
Your Honor, no questions for this witness and no objection for the witness to be released.
No objection to the release, Your Honor.
Witness is released.
Thank you.
Thank you. Do we need a moment to break before our next witness, or are you ready to go?
I'm ready, Your Honor.
Okay, call your next witness, please.
Actually, before I call the next witness, if I may introduce into evidence, by means of business record certification, I have medical records of Garrett LeBlanc, which is going to be 18 pages, and one of those pages is a business record certification. I've showed the records to defense counsel.
Yes, Your Honor, that's correct. I have no objection to these.
They're admitted.
And Your Honor, I have attached exhibit records, so this will be states 16, and for each page I've assigned a letter. It will be 16A through 16R. If I may approach.
Granted.
And the state will call Garrett LeBlanc.
All right. Good morning. Raise your right hand for me, please. Madam Clerk, will you swear the witness?
You swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
And get up as close to that microphone as you can. If you need a little help adjusting it, let me know. All right,
Is this okay?
Yeah, that's good.
Yes, sir.
Speak clearly and distinctly so we can all hear and understand you. And there's a court reporter in the back of the courthouse making a record, so it's important you're able to make a good record of what you say, okay?
Yes, sir.
If one of these lawyers objects, stop speaking until I give you an instruction on what to, how to proceed, okay?
Yes, sir.
Okay. Ms. Glisson, you may inquire.
Good morning, Mr. LeBlanc.
Good morning.
Can you please state and spell your first and last name for the record?
Garrett LeBlanc, GARRETTLE,
What's your date of birth?
3/29/84,
How old does that make you today?
42.
What city do you currently live in?
I live in Four Oaks, North Carolina.
How long have you lived there?
Coming up to a year and a half.
Have you ever lived in Okaloosa County?
Shortly.
Do you remember what years that was?
That was going to be, the accident was 2021, so about a year after my accident.
So you lived in Okaloosa County for a year after your accident?
Yeah, I got into a care home and came out and stayed right over here off Mooney Road.
Okay. So on August 22nd of 2023, do you recall where you were living?
I was down south,
Okay, so
or I was here, pardon me.
do you recall where you were living?
I believe that I was staying with Benjamin.
What city was that in?
That was here in Fort Walton.
And when you said you were living with Benjamin in Fort Walton, are you referring to Benjamin Racer?
Yes.
Approximately how long had you been living with Benjamin Racer as of August 22nd of 2023?
Month and a half.
And that was in Okaloosa County?
Yes.
Prior to living with Mr. Racer, how long had you known Mr. Racer?
I'd known Benjamin for what I believe to be about 7 years now through work. He was a former coworker.
Is it fair to say that you and Mr. Racer were friends?
Yes.
In August of 2023, did you own a vehicle?
No.
Did Mr. Racer own a vehicle?
Yes.
What type of vehicle did he own?
It was a truck.
Do you recall what color?
I believe it was white.
Now, if you didn't have a vehicle during the month of August of 2023, how would you usually get around town?
Bus.
So you use bus as means of transportation?
Yes.
On August 22nd of 2023, were you employed?
I was.
Where?
Harry T's.
Okay, what's Harry T's?
Harry T's is a bar and restaurant.
What was your job there?
I was a bartender.
Do you recall what hours, or if you worked at all, on August 22nd of 2023?
I believe that I got off relatively 3 o'clock in the afternoon.
At 3 o'clock in the afternoon, when you got off of work, what did you do?
I went to the neighbor bar and had a beer and a shot.
Did you ever at any point meet up with Benjamin Racer?
Yes, I did.
Do you recall what time that day on August 22nd you met up with
I
him?
believe that was in the time frame of 4 o'clock.
4 o'clock?
I believe so.
Where did you first meet him?
I believe the bar's name is the Red Door, and it was next to my place of employment.
Okay. So you met up with him first at Red Door?
Yes.
Now, at Red Door Saloon, do you recall what color shirt you were wearing?
I would have been wearing a blue polo, work
Okay.
polo.
Do you recall if you were wearing a hat or not?
I believe that I was wearing a hat. Yes.
When you went to a Red Door Saloon, was Benjamin Racer with you?
Yes.
Do you recall ordering some drinks at Red Door Saloon?
Oh, yeah, I do.
Do you know approximately how many drinks were ordered at Red Door Saloon?
I know for myself, I believe it was a beer and a shot of alcohol.
Do you remember who paid for the tab at Red Door Saloon?
That I do not remember.
Would it be common if you and Benjamin Racer were out drinking that one person would pay for the tab for the both?
It would be.
It would be?
Yes.
Do you know approximately how long you were at Red Door Saloon?
I believe that it was in the vicinity of 45 minutes to an hour.
Were you drinking shots at the Red Door Saloon?
I was.
Was Mr. Racer also drinking shots?
I'm not aware of quite of what he was drinking at the time.
At the Red Door Saloon?
Yes.
Okay. Did you at any point see Mr. Racer drinking any type of alcoholic beverage at the Red Door Saloon?
Yes.
Do you know what he was drinking?
I don't.
Do you know if it was whiskey or beer or both?
May have been both or one or other. That's what I was drinking.
Okay. Do you recall what Mr. Racer was wearing that day when you first met up at Red Door Saloon?
I believe it would have been shorts and a Hawaiian shirt.
What type of hairstyle did Benjamin Racer have?
Hair pulled in a bun.
After you left Red Door Saloon, did you and Mr. Racer travel to Boathouse Oyster Bar?
We did.
Did you walk or travel by vehicle?
We walked.
When you got to Boathouse, were alcoholic drinks ordered when you got there?
Yes.
Were you drinking?
Yes.
Was Mr. Racer drinking?
Yes.
What was Mr. Racer drinking?
I'm going to imagine beer and whiskey.
Do you recall?
More than likely, yes.
When you say whiskey, do you know what type of whiskey Mr. Racer was drinking at Boathouse?
I know that I was drinking Jameson.
You were drinking Jameson?
I was drinking Jameson.
What was Mr. Racer drinking?
I would imagine something along that lines, being that we would have one and the same.
Do you recall how many drinks Mr. Racer had at Boathouse?
No, I do not.
And at Boathouse, were you still wearing the same clothing that you were wearing at
Yes.
Red Door?
Yes.
After you and Mr. Racer left Boathouse Oyster Bar, did you two go to the Whiskey Barn?
Yes.
How did you and Mr. Racer get to the Whiskey Barn?
Benjamin drove.
Did Mr. Racer drive his own truck there?
Yes,
Were you in the passenger seat of that truck?
I was.
Do you remember arriving at the Whiskey Barn?
Vaguely, yes.
When you arrived at the Whiskey Barn, do you remember what you were doing there?
I remember ordering another beer and whiskey and then playing pool.
Did you see Mr. Racer order any drinks?
I believe that I was with Benjamin when we first ordered around, but after that I did not know.
The round that you ordered that you were there with him?
Initially walked in and ordered around, yes.
The round that you ordered, what was that?
That would have been a beer and a whiskey.
What type of whiskey?
Jameson.
So you and Mr. Racer had a Jameson?
Yes.
Are you familiar as a bartender what a standard shot pour is?
It should be 1.5 ounce.
How many shots did you request, or how many shots were in the drinks that you were served that round at Whiskey Barn?
At the Whiskey Barn, as a professional, I would call it a 4-ounce pour.
Now, at the Whiskey Barn, were you playing pool?
Yes.
Do you recall seeing Mr. Racer fall when he was walking to the bathroom at Whiskey Barn?
Did not recall that.
Okay. If you don't recall it, that's okay. You just say you don't recall.
I didn't recall, no.
Okay. Now, what's the last thing that you remember from the Whiskey Barn?
The last thing I remember from the Whiskey Barn is coming from the pool table to find that it was time for us to go. And we went to the truck, got in the truck, and we left.
Okay. Do you recall who was driving the truck when you left the Whiskey Barn?
Benjamin.
Where were you located in the truck?
I was in a passenger seat.
And where were you two headed after you left the Whiskey Barn?
We were headed back to Benjamin's house.
Okay. Do you recall the address of where that was located?
I do not know the address, no.
How far away was Benjamin's house where you were living located from the Whiskey
I
Barn?
was under the impression that it was right around the corner.
So you're in the passenger seat, Benjamin is driving. Do you remember the route that was taken?
I do remember that we took a wrong turn at some point.
Okay. When you took a wrong turn, did Mr. Racer turn around or anything?
I remember it was brought to my attention that we made a wrong turn. I do remember an acceleration, and that's about the end of my night.
Do you remember anything about the crash itself?
No.
Right prior to the crash, whenever Mr. Racer was driving after leaving Whiskey Barn, do you recall the manner in which Mr. Racer was driving?
I would call it, from what I very remember at the end, erratic.
What does erratic mean to you?
Fast and unpredictable.
Was there, when he was driving erratic, fast, unpredictable, how did that make you feel?
I remember feeling uncomfortable.
Was he saying anything to you at the time when he was driving fast?
That I do not remember.
Do you recall if he had his headlights on or not?
I would recall, I imagine, so I can't, yes.
Approximately how long was Benjamin Racer driving erratically for prior to the crash?
I don't remember that long.
Were you scared?
It did make me uncomfortable, yes.
Uncomfortable?
Yeah.
Okay. And after you have this last memory of Benjamin Racer driving erratically, what's the next thing you remember?
I remember a lady officer telling me that everything was going to be fine and that they were going to try and get me to, I think I was having trouble breathing.
Do you recall whenever you heard that lady speaking to you, were you on scene of the crash?
Yes.
Were you in and out of consciousness?
Yes.
So after that memory, what's your next memory that you have?
Vaguely the next morning, there was an officer that came and asked some questions.
Where were you when you woke up that next morning?
I was in this hospital right here and just around the corner.
In Fort Walton Beach?
Yeah.
Mr. LeBlanc, how long were you in the hospital here in Fort Walton Beach?
I believe it was just a bit over 3 months.
Okay. So from the night of the crash to 3 months later, you were in the hospital?
Yes.
Were you ever placed in the ICU, the intensive care unit?
I believe I was placed in ICU right away.
Prior to the crash, did you have any disfigurement on your body?
No.
Did you have any permanent injuries prior to the crash?
No.
Prior to the crash, were you able to walk?
Yes.
Were you able to extend your wrists? Were you able to extend your arms?
Yes.
Were you able to bend your knees?
Yes.
After the crash, when you woke up in the hospital and you gained consciousness, were you able to extend your wrists?
I was unable to move from the neck down for 3 months.
You were unable to move from the neck down completely?
Anything.
Did you have any sensation from the neck down?
No.
For 3 months?
Yes, ma'am.
So during those 3 months, were you able to use the restroom by yourself?
No.
Were you able to eat by yourself?
No.
Did you require a round-the-clock caretaker at the hospital?
Yes.
Were you in any pain while you were in the hospital for those 3 months?
Yes.
Were you given pain medication?
Yes.
Did you ever have to have any type of surgery when you were in the hospital?
No.
Now, it's almost been 3 years after the crash. Have you received any type of other care, therapy, rehabilitation since you were released from your 3-month stay in the hospital?
I collect I collect Social Security, so I get a certain small amount of physical therapy every year. So once I left the hospital, I stayed at a care home, Chautauqua Springs in Defuniak Springs, received a little bit of care there, and then through a medical mall in where I live, I received very, very minimal.
When you were discharged...
Very minimal.
I'm sorry?
I said very minimal.
When you were discharged from the hospital 3 months after the crash, where were you discharged to?
Chautauqua Springs in Defuniak Springs.
What is Chautauqua
It's
Springs?
a care home and rehabilitation center.
Is that where you lived?
Yes.
How long did you live in this rehabilitation center?
I believe it was close to 10 months,
10
I think.
months. When you were there for 10 months, were you able to gain any function of your body from the neck down due to any type of rehabilitation?
I am considered 90% disabled.
Okay. Are there any, today, as it stands 3 years later, do you have sensation over every part of your body?
No.
What do you not have sensation over?
My feet, my legs, my knees, my hands.
Okay. Are you able to lift your arms?
Minimally.
Okay. What about your wrists? Are you able to extend your wrists?
Minimally.
Okay. What about your legs? Are you able to walk?
Barely.
Are you able to walk unassisted?
Barely.
Is there anything that you've noticed on your body since the date of the crash that's permanently disfigured?
90% of I'm 90% disabled.
Okay. The muscles in your hands, are those muscles weak?
Yes.
Are you able to open your hands completely?
No.
Is there one hand that's worse than the other?
Yes.
Is there one you could show us? Are you able to open your fingers?
No.
Are you trying to open your fingers right now?
Yes.
And what about, let's show us the right hand. Are you opening your fingers as much as you can?
Yes.
Okay, thank you.
You're welcome.
3 years after the crash, are there any other physical disabilities that you have that you can't do today that you could do the day of right before the crash?
Just about everything in my life.
Are you able to play pool?
No.
Why not?
I can't extend my arms. Would not be able to hold the stick.
The person that you said was driving right before the crash, after leaving Whiskey Barn, who you indicated was driving erratically, do you see that person in the courtroom here today?
Yes, ma'am.
Can you please point to and identify, as best you can, an article of clothing that he is wearing?
Be Benjamin in the green.
And For the record, the witness has identified the defendant, Benjamin Racer. May I have one moment, Your Honor?
Granted. Mr. Conch.
Yes, Your Honor. Good morning, Mr. LeBlanc.
Morning.
Back on August 12, 2023, at that whiskey bar, do you remember the male bartender at that establishment?
Yes.
Okay. His name is John Welcher. I don't know if that rings a bell, but he was your bartender that night.
Okay.
Or that afternoon to evening. And then, this is still on August 12, 2023. At some point at that whiskey bar, John Welcher ultimately cut you guys off from serving alcohol. Do you recall that?
Sure.
Okay. Do you recall Mr. Welcher asking you if you were going to drive?
No.
Okay. Do you recall showing Mr. Welcher, that male bartender, that you had the keys?
No.
Okay. After you left that whiskey bar, do you recall making any stops before the accident occurred?
No.
Okay. And let me just phrase it this way. You answered no, as in I don't recall, or that you made 0 stops once you left the whiskey bar?
No, that I don't recall making any stops.
And at that time, when you guys left that whiskey bar, you said you were bartending at Harry T's, went to the Red Door, then that whiskey bar, consuming alcoholic beverages, as you stated. At that time, when you left the whiskey bar, maybe on a scale of 1 through 10 of how impaired you were at that time, what would you rate that? 0 being dead sober, and then 10 being completely blackout?
I would have been about an 8.
An 8.
Yes, sir.
And is it possible, I know you said you didn't recall that a stop was made once you left that whiskey bar?
I do not recall.
I'm sorry?
I do not recall
You
that at all.
Yes, Your Honor. No further questions, Your Honor, for this witness.
All right. Redirect.
No, Your Honor.
All right, is the witness released?
Yes, Your Honor.
All right.
No objection from the defense, Your Honor.
Thank you very much,
You're welcome.
Mr. LeBlanc. Good day.
May I return the exhibits to the clerk, Your Honor?
Granted. Your next witness, please.
Your Honor, the state would rest.
All right. Do you wish to have a brief moment with your client and maybe actually get Mr. Middleton on the phone again during that time?
I would request a brief moment in the client attorney room, Your Honor, and if I may, just raise a motion at this time, just procedurally.
All right. All right.
At this time, the state has rested. Defense would move for judgment of acquittal. Our argument would be they failed to present a prima facie case, Your Honor, in the light most favorable to the state. I do not have any case law to present to this court, Your Honor.
All right. And I guess technically, since we don't have a jury, it's actually, I guess I'm confused. would still be an acquittal, but I guess it would be for involuntary dismissal since we don't have a jury. But at any rate,
Yes, Your Honor.
you know, I like the academic part of it. I understand.
Thank you,
Any
Judge.
response from the state as to the request for involuntary dismissal?
Yes, Your Honor. Just for brief case law, Brown v. State, 243 Southern 3rd, 1037. It's a Florida First DCA case out of 2018. On a motion for judgment of acquittal, the trial court should not grant the motion unless the evidence, when viewed in the light most favorable to the state, does not establish a prima facie case of guilt. In our case, we have 2 counts, the first one being driving under the influence, manslaughter, which has the element that Mr. Racer was in actual physical control of the vehicle or drove that vehicle. We have testimony from law enforcement officers, we have body camera from those officers showing Mr. Racer with his hands actually on the vehicle. We have body camera evidence showing the keys were in the ignition. Testimony as well that the keys were in the ignition, as indicated by the dinging that occurs when the keys are in the ignition of a vehicle. We have testimony and surveillance. We have testimony from the passenger in that vehicle, Mr. LeBlanc. We have surveillance from the Whiskey Barn, the last establishment that both had visited, showing Mr. Racer entering that vehicle and then driving off the premises. And so we feel like we have met at least a prima facie case for count 1, Your Honor, or element 1. With respect to element 2, which is driving or an actual physical control of the vehicle, Mr. Racer was either A, under the influence of an alcoholic beverage to the extent that his normal faculties were impaired. We feel as though we have established this through the surveillance video at the Whiskey Barn footage, at the Whiskey Barn showing Mr. Racer actually falling over and having to be cut off from the service of alcohol shortly before entering his vehicle and proceeding to drive. We also feel as though we have established this through the surveillance or the intox room video where Corporal Mooney performed standardized field sobriety exercises where we see multiple indicators of impairment at that time, Your Honor, namely or specifically one where at one point in time Mr. Racer had to use the wall and the box to stop himself from falling over during the walk and turn test, Your Honor. So we feel as though we have shown beyond a prima facie case that he was impaired and that his normal faculties were impaired. However, there is also a second component that we could prove, which is he had a blood or breath alcohol level of 0.08 or more. We have done so both in the testimony of the FDLE expert, Mr. Graham, as well as the breath alcohol test that was administered by Corporal Mooney, showing, I believe it was a 0.148 and a 0.140 as both of those samples of breath. So we feel as though either if you look at the normal faculties being impaired or the breath alcohol or blood alcohol levels, that we have established a prima facie case of guilt there. The last element, Your Honor, is that as a result of driving the vehicle, Mr. Racer caused or contributed to cause the death of Mr. Demetrius Thomas. We heard testimony from the medical examiner regarding the fatal injuries that Mr. Demetrius Thomas sustained. The fact that he had, I think it was 18 of 24 ribs that were bruised. He had the laceration of the heart. The medical examiner testified that those were caused by blunt force trauma. And so we would state that we have established a prima facie case of guilt for all 3 elements on count 1. With respect to count 2, just for the sake of brevity, elements 1 and 2 are essentially the same as count 1. And we do feel as though we've established a prima facie case of guilt for both of those. With respect to element 3, that as a result of operating that vehicle, Mr. Racer caused or contributed to causing serious bodily injury to Mr. LeBlanc. We heard the testimony from Mr. LeBlanc moments ago regarding the life-altering injuries that he sustained and that he is still dealing with to this day. Your Honor, we feel as though we have met the burden, at least at this point, of a prima facie case of guilt and that the motion for judgment of acquittal should be denied.
Any response, Mr. Cox?
No response from the defense, Your Honor. Thank you.
Based on the finding the court must make to grant the motion, the court cannot make that, which the standard is that taking the evidence and all proper inferences of that evidence in the light most favorable to the non-moving party, the court would have to come to the conclusion that there's no judgment other than that in favor of the moving party, and the court cannot make that finding. The motion is denied. All right, if you'll put Mr. Rase in the interview room and allow Mr. Koch to have access, and Mr. Koch will contact Mr. Middleton so he'll be available as well.
Yes, Your Honor.
Okay, and so we'll be in recess at this time. Simply let me know when you're available, and we'll reconvene.
Yes, Judge.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
and Mr. Middleton in the private room. It's my understanding my client does not wish to testify this afternoon. If we could please swear him in to confirm that.
At the lectern, please.
Yes, Your Honor. Come, please. Mr. Rase.
All right, and raise your right hand as best you can for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. Now, we took a recess where you were able to talk to Mr. Koch and I believe Mr. Middleton as well. Is that right?
Yes, sir.
Now, I'm going to have a discussion with you about your conversation with them about the decision to testify. Now, I don't want you to tell me specifically your discussions or tell me the advice that they gave you, except for one question at the very end, and it'll be obvious. But I'm going to ask you questions about that discussion and ask you to answer those. Did you have adequate time to talk to them about the decision to testify or not testify?
I believe so.
All right. And did you discuss with them why it could be a good idea to testify? Did they explain to you why, under what circumstances it might be a good idea to testify?
No, it was more why it would not be a good idea to testify.
Okay. And so they answered your questions about that?
Correct.
All right. After that discussion, have you come to a decision of whether you want to testify or not?
I think I haven't came to that decision in my heart and mind yet. I'd like to think about it over a day at least.
Okay, I don't think I can give you a day to think about it because we're in trial now and the state is rested. If you have specific questions about the decision, about the positives and the negatives, I can give you some more time to chat with your lawyers in the privacy of the interview room so that you can discuss that and you can ask them specific questions about the positives and the negatives of making the decision. But I can't provide you a day to make that decision. That would have to be done fairly promptly because we're in the middle of trial.
Right. I've been kind of advised to not, so I guess I'm just going to not testify.
All right, so I'm going to restate what I understand. You, after discussing it with your lawyers' advice to you is that it would be in your best interest not to testify, and you've expressed uncertainty about that, but you've made the decision to follow your lawyer's advice.
Correct.
Okay. Are there any questions that they haven't answered about your decision to testify or not testify?
I'm sorry, question again?
Are there any questions that you have for your lawyers about the decision to testify or not testify that your lawyers have not answered for you?
No.
Okay. All right, anything further, Mr. Koch?
Nothing further, Your Honor.
Mr. Middleton, anything further for this discussion about the defendant's decision to testify or not?
No, Your Honor.
Okay, all right. Based upon this discussion, although clearly the defendant is struggling with the decision and is uncertain, the defendant has made a free and voluntary decision to accept his lawyer's advice and not testify. And that's consistent with, based upon the defendant's representation, that's consistent with his lawyer's advice that it would not be in his best interest to testify. And so the court will find it to be a free and voluntary decision. All right? Does it sound reasonable for us to take our lunch recess, and then we'll hear closing arguments after lunch?
That defense has no objection to that, Your Honor. Yeah, no objection. I plan on resting, re-raising my JOA, and moving to closing, Your Honor.
Either way, Your Honor,
All
prepared
right.
to go forward now or after lunch.
Well, I'd like to get some lunch in my
Yes,
belly
sir.
before I listen to closing arguments.
Yes, sir.
All right, so we'll take our lunch recess. Is 30 minutes sufficient?
Yes, Your Honor.
Yes, Your Honor, for defense.
And that will give you adequate time to be prepared?
Yes, sir.
Okay, all right. All right, we'll see you then. Well, let's just call it 1 o'clock. It's 12:26 now is what I show. Okay? All right, please be seated. Mr. Koch?
Yes, Your Honor. At this time, the defense would rest, and I would re-raise my judgment of acquittal motion, Your Honor, with no added case law or testimony.
All right, motion's denied.
And may I be heard briefly on another matter, Your Honor?
Yes.
Before closing, there is a, I know we're not doing jury instructions, of course, it's a bench trial, but I'm asking for the defense of inoperability to be, I know we're not doing jury instructions, but allowed for me to address during closing for this case.
The what now?
Defense of inoperability, Your Honor.
Inoperability, okay.
Yes, sir, for DUI, if I may just lay a little, and then may I go to the podium, Your Honor?
Yes, sir. Yes, sir. Please.
And it's in the jury instructions, the defense of inoperability. At first, and just the defense alone, Your Honor, for DUI cases, it's mostly in situations when the vehicle is inoperable. They first look at why is the vehicle inoperable. Case law looks at dead batteries, stuck in a ditch, how inoperable. I think in this case, I won't go too hard on this one because clearly, especially through Exhibit 5, Picture 36, Corporal Marcus Montgomery, where we showed the front end, or the state showed the front end of the pickup truck, and testimony from Mr. Montgomery, front bumper twisted, steering wheel airbag, glove box airbag deployed. They had to cut off the passenger's side door, and the passenger front wheel was actually folded under itself. So not only was this vehicle not able to run, but it wouldn't even be able to push or roll. So I'm fairly certain, or I can express to this court, that the vehicle was inoperable. The biggest issue to analyze is this defense cannot be raised if the person driving the car caused the crash, through my understanding, through case law, Your Honor. Now, the evidence before us, and I'd push to the court, is there's about, I'll give you the exact time. The last time we saw my client drive that pickup truck was the surveillance footage from the whiskey bar. And the time stamp was 8:55:46, so the hour of 8 o'clock, 55 minutes, 46 seconds. That was the last frame when we saw Mr. Razor enter that vehicle. And testimony from multiple officers when the call was made, it's just roughly around 9 o'clock, maybe 9:01. So there is a gap, just say roughly 5 minutes, that I'm putting forth to this court that we don't know what happened. Now, after the accident, or let me phrase that, there was no witness or any testimony or evidence putting my client behind the wheel at the moment of impact. And I'd like to go forward with the civilian witnesses, Mercedes Claiborne, She stated she never saw anyone in that vehicle before the crash. She even said she only approached the white car, never approached the truck. The furthest she got to the truck was across the street, and she did see Mr. Rase being pulled from the driver's side. The testimony was that the passenger side was pinned, the door could not be opened, and I asked her when she was across the street, could you see inside the the vehicle? She said she could not. So I'd push back on Ms. Claiborne as a wheel witness that wouldn't allow my defense because she never saw my client before the crash, and she doesn't know how many people were in the vehicle. And if you recall, she said the headlights were facing away from her, so she really was at a disadvantage of knowing what exactly was going on in that vehicle. Richard Cola testified. He was right at that intersection, but he did testify that I had to do a drop-off order for Chipotle, and by the time he returned, the individual he believed to be Mr. Rase was already being carted off on a gurney by EMS. Ms. Stott, I'm going to call the first law enforcement, not on scene, but the first to go to the truck. You saw through her video, body cam, that the driver's side door was open. The vehicle, the passenger side we know was pinned, that was not open, and there was multiple civilians on that driver's side. It's very unique in this situation, because reading through that case law, it's mostly, or not mostly, but a vehicle in a ditch with no one, just the driver. Here, by the time law enforcement showed up, there was multiple civilians on scene. The driver's side door was open, and we know the damage to the vehicle. And the next thing I'd like to analyze is statements by my client that was brought forth to this court. We heard, "I'm sorry," through the body camera, but nothing specifically putting my client behind or admitting to driving during that crash. That moment of the crash, when he left that whiskey bar into the crash, no one put him behind the wheel before that crash, Your Honor. And then post-crash, the vehicle was inoperable, and yes, he was behind the vehicle, or excuse me, behind the steering wheel with the keys in the ignition, of course not on, in an inoperable vehicle. For those reasons, I'm requesting for the defense of inoperability, Your Honor.
Response?
Your Honor, I think that's an argument that the defense can make in closing. I will have the right to rebut that, but I don't see any issue with defense counsel making that argument, and the court, according to the jury instruction, the court, as a trier of fact, applying the jury instruction as if a jury were to be interpreting that jury instruction. So, there are specific guidelines in the jury instruction indicating that it is not a defense if the defendant was driving under the influence before the vehicle became inoperable. So I think that we can cross that bridge when we get there, but I do think Mr. Koch is free to make that argument.
All right. So ordered. All right. You ready to go forward?
Yes, Your Honor.
All right.
May I proceed?
Granted.
Your Honor, in this case, the defendant is charged with DUI manslaughter and DUI serious bodily injury. To prove the crime of driving under the influence manslaughter, the state must prove the following three elements beyond a reasonable doubt. And I want to start with the first element for count one, but it's also the exact same element for count one in the DUI serious bodily injury count. And that first element is that Benjamin David Rase drove or was in actual physical control of the vehicle. How do we know that Benjamin Rase drove or was in actual physical control of a vehicle? We know the defendant drove or was in actual physical control based upon the following evidence that was introduced in this trial. We saw body camera footage of Mr. Rase in the driver's seat with his hands on the steering wheel. We saw photographs of the keys fully in the ignition of that truck. We audibly heard the ding, ding, ding that was being illuminated due to those keys being in the ignition. We also heard testimony from witness Mercedes Claiborne, who indicated she was on scene immediately after the crash. She saw Mr. Racer was the one sitting in the truck, and she indicated that she at no time saw anyone else exiting that truck driver's side. Additionally, when Officer Stott arrives on scene, the defendant makes spontaneous statements saying, "I'm sorry, I'm sorry." If he wasn't driving the vehicle, what exactly is he sorry for? I submit to you that's strong evidence that he's sorry for causing that crash. But we also have the fact that this is Mr. Racer's truck. We heard this through the testimony of Mr. LeBlanc. We heard this through the officer's testimony that this truck that was involved in this crash that Mr. Racer was sitting in the driver's side of was registered to Mr. Racer. We saw footage of Mr. Racer driving the car from the Boathouse Oyster Bar, leaving the parking lot of the Boathouse Oyster Bar. We saw video footage of Mr. Racer getting into the driver's seat of that gray Ford truck, which I would argue had the same cooler or a similar styled cooler as the one that was found at this scene. Mr. Racer had the car keys in his hand, and he entered into the driver's seat of that truck at approximately 8:55 p.m., and the crash occurred around 8:59 p.m. And we know the 8:59 p.m. because Miss Claiborne said immediately after the crash she called 911, and we heard the officers testify that the 911 dispatch came in at approximately 8:59. Additionally, we heard testimony from the surviving victim, Mr. Garrett LeBlanc. He indicated that Mr. Racer was the one driving the vehicle at the time of the crash. And in fact, he went on to elaborate and say he was actually driving erratically. It made him feel uncomfortable. So we do actually have a witness that testified that Mr. Racer was the one driving the vehicle. The truck also had a Michigan tag. And I asked that question because in the defendant's interview, the court heard he made statements, the defendant made statements that he just moved down here from Michigan. So again, that's a tag that's registered to him. That truck is Mr. Racer's truck. I think that evidence is uncontroverted. Mr. Racer was the one driving this vehicle. There is no other Mr. LeBlanc was unconscious on the scene. When officers arrived immediately after the call came out, Mr. LeBlanc is unconscious. Mr. LeBlanc is unconscious. There's no way they could have even possibly switched seats at that time. So Mr. Racer was in either actual physical control of that vehicle, or in the alternative, which the law allows for, Mr. Racer was the one that was driving that vehicle. Based upon all of the evidence that's been presented, the totality of the circumstances, the video footage, which is a very, very heavy portion of that, I would submit to the court that the state has proven the first element beyond a reasonable doubt for counts 1 and counts 2. Additionally, so the second element of DUI manslaughter that the state must prove beyond a reasonable doubt is also the same as the second element in count 2 for DUI with serious bodily injury. And that element, the state is required to prove as follows. While driving or in actual physical control of the vehicle, Benjamin David Racer was under the influence of alcoholic beverages to the extent that his normal faculties were impaired, or he had a blood alcohol level of 0.08 or more grams of alcohol per 100 milliliters of blood, or he had a breath alcohol level of 0.08 or more grams of alcohol per 210 liters of breath. In order to prove the second element of these, for the 2 counts, the state only has to prove one of those theories beyond a reasonable doubt. However, I would submit to Your Honor that the evidence is so overwhelming, the state's actually proven all 3 theories beyond a reasonable doubt, but I want to go into a little bit of each theory. Starting with the first theory, was the defendant under the influence of alcohol to the extent his normal faculties were impaired? The law defines normal faculties to include, but not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general, to normally perform the many mental and physical acts of our daily lives. We heard from expert Thomas Graham with FDLE, who educated us a little bit on pharmacology, how alcohol affects the body. He indicated that the ingestion of ethyl alcohol, which is in whiskey, such as Jameson and beer, can affect someone's mood swings, the ability to walk, their normal faculties, their ability to make good judgments, make decisions. And what we saw throughout this trial within the evidence was video footage of Mr. Racer falling. He face planted on the way to the bathroom. I would submit to Your Honor that's a very, very strong indicator that Mr. Racer's normal faculties were impaired. And that was about not even 30 minutes prior to him getting into the vehicle and driving away. We also see him on the way to the vehicle before he gets in the driver's seat. He walks completely out of his flip-flop and doesn't even really realize it. And he just continues walking to the car. We see how he's swaying. We see how he can barely stand up. We see him almost fall over when he gets up from the bar at Whiskey Barn. We've seen the Intoxilizer video where he was performing field sobriety tests, and that was quite some time even after the crash. He almost fell down quite a number of times while he was performing the field sobriety exercises, which he failed, every one of them. The Intoxilizer video, the field sobriety exercises that we saw with our own eyes, that speaks for themselves. We also heard his slurred speech when he's apologizing to Officer Sott. I'm sorry. His speech sounded a little slurred at that time. We also heard we heard the bartenders from Whiskey Barn. Miss Ann Grady, she testified that she actually left the bar because Mr. Racer was being so loud and so obnoxious. And then Mr. Welchel, who come in and relieved Miss Grady, said, yeah, he was actually quiet. And then we see how he acted whenever Officer Stott made contact to him. He's saying, I'm sorry. And then we saw his demeanor in the hospital. So we have what I would submit to be evidence of mood swings, change of emotion, which can be affected by the ingestion of ethyl alcohol. And that's a very, very big indicator that this defendant's normal faculties were in fact impaired at the time of crash. The second theory that the law allows the state to proceed under to satisfy element 2 in counts 1 and 2 is that the defendant, did he have a blood alcohol level of 0.08 or more grams of alcohol per 100 milliliters of blood. We heard that the defendant's blood was drawn pursuant to a search warrant at approximately 11:51 p.m. on the same day of the crash, which is going to be about 2 hours and 52 minutes after the crash. We heard expert Thomas Graham testify that he tested 2 samples of Mr. Racer's blood, and that the blood results were a blood alcohol concentration of a 0.187 and a 0.186, indicating that his blood alcohol level 2 hours and 52 minutes was over 2 times the legal limit. The last theory that the state could prove the second element under is, did the defendant have a breath alcohol level of 0.08 or more grams of alcohol per 210 liters of breath? We heard testimony from the officers at 1:16 a.m. the morning after the crash, which from my math is approximately 4 hours and 17 minutes after the crash. We saw and heard the breath test was given, and we actually stopped the video a little early. The Intoxilizer video where we saw the field sobriety exercises, that's when the breath test is administered. That is in evidence if the court wishes to hear. We presented it through testimony, but it is on video that Officer Mooney gave Mr. Racer the breath test, 2 samples. The results, 0.148, 0.140. And that's 4 hours and 17 minutes after the crash. I submit to you element number 2, for count 2 and count 1 have been proven beyond a reasonable doubt with all 3 theories. But furthermore, the level of his normal faculties being impaired also goes to support the accuracy of these results, of the test results, of the blood and of the breath. The final element for DUI manslaughter and DUI serious bodily injury are slightly different from each other, so I want to address them separately. In count 1 for DUI manslaughter, the third element states, as a result of operating the vehicle, Benjamin David Racer caused or contributed to the cause of death of Demetrius Thomas. And what facts are the state going to use to prove that beyond a reasonable doubt? Well, first, we heard and saw testimony that showed the defendant failed to stop at a 4-way stop sign while traveling north at the intersection of Holmes Boulevard and Wright Parkway. At the time that the defendant was traveling through the intersection after running the stop sign, we can clearly see on video the defendant didn't stop at the 4-way stop. Mr. Thomas did. Mr. Racer did not. But in addition to failing to stop at that 4-way stop, we had Officer Montgomery, who is a crash reconstruction expert, testify that his speed calculations indicated somewhere in the range of 60 to 70 miles per hour. And that testimony is corroborated by both of the civilians, Mr. Kala and Ms. Claiborne, indicating that he was going very fast in a 30-mile-an-hour zone, mind you. This is a school zone. We heard testimony. We saw the photographs that indicate this is a school zone. Silver Sand School, which is where the video footage came from, is in fact a school zone. It's a residential area. He was going at least twice the speed limit that was posted visibly. There was a visible sign there, we heard. All the stop signs were visible. There was nothing obstructing the stop signs. What obstructed Mr. Racer from stopping at those stop signs is because he was under the influence of alcohol to the extent his normal faculties were impaired. As a result of Mr. Racer's failure to stop at the stop sign, he T-boned, essentially, it's a T-bone, Mr. Thomas. Hit the front of his Ford truck, hit Mr. Thomas's left side of his vehicle. And we see that the vehicle, Mr. Thomas's vehicle, travels backwards and lands in the final resting place. As we saw on the crash, in the crime scene photos, we saw how those vehicles were positioned. The vehicles, it was testified to that the vehicles, this was consistent with a T-bone crash. The crash actually pushed Mr. Thomas's car back 87 feet from the point of impact, which the point of impact was determined to be in the intersection. And the only reason those vehicles came to a rest is because Mr. Thomas's vehicle hit that power pole, pinning him in, preventing fire department and EMS from getting to him. We heard testimony from Dr. Lopez this morning that the victim, Demetrius Thomas's cause of death was blunt force trauma based upon the multiple internal injuries that was consistent with being involved in a car crash. Mr. Racer's truck hit Mr. Thomas's vehicle so hard, Your Honor, that the organs that were inside of Mr. Thomas's body that should be in the center of your chest cavity or on the left side of your chest cavity had been shifted completely to the right side of his body. We saw the photographs of his heart. His heart basically ruptured. If he did survive for a few seconds, he would have been in extreme pain and unable to breathe. Mr. Thomas, he suffered a significant blow, immediately killing him. And if he didn't die immediately, it would just be a few seconds. That Mr. Thomas would not have died but for the defendant failing to run the stop sign. If he hadn't have run the stop sign while speeding, Mr. Thomas would still be alive today. So although the state only has to prove as a result of operating the vehicle Benjamin David Racer caused or contributed to the cause of death of Demetrius Thomas, I submit the evidence shows that the defendant not only contributed to this crash, but he in fact caused this crash. I don't have to prove both, but I submit that we have, Your Honor. Based upon the evidence that we've heard, the videos, and the testimony, I submit to you that the state has proven the third element beyond a reasonable doubt, satisfying all of the elements of DUI manslaughter. Now, moving on to count 2, element 3, to prove the crime of driving under the influence causing or contributing to causing serious bodily injury, the state must prove the following third element. As a result of operating the vehicle, Benjamin David Racer caused or contributed to causing serious bodily injury to Garrett LeBlanc. And the law provides serious bodily injury means a physical condition that creates a substantial risk of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. And before I begin to discuss the medical records that have been introduced into evidence as State 16 composite, I'd like to remind the court that we saw Mr. LeBlanc on video just prior to the crash. We saw a lot of footage, actually, and the state only chose to publish selected portions of the videos, but the entire videos, all of the clips, are in evidence if the court needs to review those. But we saw Mr. Blanc. What was he doing? He was playing pool at the Whiskey Barn. He was walking normally. He was drinking with his hands. You see his arms extend. You see his legs walking. You see him able to drink his own drink. You see him moving about in a normal way. However, today we saw Mr. Garrett LeBlanc. I asked him if he could extend his hands, and he showed the courts. He also testified he's not able to fully extend his fingers. He's not fully able to use his arms, to use his legs. He indicated he can't do anything that he used to do. And this is 3 years later, after a 3-month hospital stay and 1 year in a rehab facility. Mr. LeBlanc testified that he no longer has full function of his body. And the 3 months that he was in the hospital, he said he had no feeling, no sensation, no movement from the neck down. I would submit to you that that evidence alone, that testimony would be enough to meet the state's burden of proving serious bodily injury. But I entered into evidence State 16, which is a composite. And I want to just briefly indicate, on the record to the court, the evidence is, the exhibit is in evidence, but I'm going to refer to the page number, and each page is numbered 16A, 16B. So I want to just briefly touch on the medical records, which is stamped to be Garrett LeBlanc's, and this is under a business record certification. Just briefly, it shows 16B, the arrival date to the ED, 18/22/23. I'm going to read verbatim from these medical records so I'm not misinterpreting anything. 16D says, the box is checked. It says laceration/wound location, size 3-inch right eyebrow. 16E, PT arrived via EMS to Trauma Bay 2 as level 1 trauma activation. Foreign body seen in throat on CT. Foreign body reviewed by Dr. Sailors. Foreign body noted to be a tooth. Patient intubated. 16F, it's titled to be a consultation report. The consultant is Timothy Monroe, MD, which later in the records indicate he's a neurosurgeon. The date of this consultation is 8/23/2023. Reason for consultation, spinal cord injury. There's a history of present illness. There's a paragraph. The last sentence says, due to his lack of motor and sensory function in his extremities, an MRI was obtained that revealed evidence of spinal cord compression and signal change consistent with a spinal cord injury. Under the section of physical examination, also on 16F, he has no motor or sensation function in the left upper extremity. In the right upper extremity, hand grip is 0/5. Hand extrinsics are 0/5. Wrist extension is 0/5. Biceps are 4-/5. Triceps are 0/5. Lower extremities are 0/5. And he has no sensation in his lower extremities. The records go on and on to detail the extent of his injuries, but I'll point out it just really just summarizes all of the injuries right here in 16I. This is a brain and spinal cord injury program medical eligibility screening. Medical stability. Does the patient have the following? And there's check boxes. A, active life-threatening condition present, and in parentheses it says E.G. sepsis, respiratory or other condition requiring systematic therapeutic measures. The box checked is yes. C lists, does intracranial pressure or arterial monitor? Yes. Under Roman numeral 2, spinal cord injury. A, did the injury result from trauma to the spinal cord? The checkbox yes is checked. B, did the lesion result in significant involvement and functional limitation of 2 or more of the following? 1, motor deficit, yes. 2, sensory deficit, yes. 3, bowel/bladder dysfunction, yes. This form on page 16I that I just read from is signed by a physician, and it's dated August 30th of 2023. And lastly, that I'd like to publish on the record is 16J. It's a discharge summary, as it's titled, and it says discharge date. And these are all records from HCA Fort Walton Destin Hospital. Discharge date, November 20th, 2023. That would be 1 day shy, 2 days shy of being 3 months from the crash. Discharge diagnosis problem list. Spinal cord injury with incomplete quadriplegia. Cord contusion around the level C5 and C6. Cervical spondylosis. Depression. History of anxiety. Stage 1 pressure wound to sacrum. And I said that was the last thing, but I'd like to put one more. 16M, which is also under the discharge summary. It indicates the follow-up appointments to be with Monroe Timothy, MD, specialty, neurological surgery. The physician attestation says the patient was seen and examined on trauma rounds this morning, where he has been recovering from C5/C6 cord contusion with quadriplegia. I'm reading as it's written, quadriplegia, from a motor vehicle accident on 8/22/23. Patient has had some, again, of function in his extremities, upper, greater, lower. He continues to work with therapy, and from our perspective, he will be available to discharge to a long-term care facility should a bed become available. And we hear that Mr. LeBlanc testified that he did, in fact, go to a long-term facility that I believe he testified he was a patient at for 10 months. So with the medical records, the testimony from Mr. LeBlanc, combined with the footage that we saw of what he was like before the crash, I would submit to the court that the state has satisfied the third and final element of count 2, that Mr. Racer, as a result of his driving, of his contributing or causing the crash, did in fact cause serious bodily injury to Mr. Garrett LeBlanc. This is a case that has overwhelming evidence. It's overwhelming. And considering all of the testimony, all of the exhibits that's been entered into evidence, the state submits to the court that the state has proven both counts, 1 and count 2, beyond a reasonable doubt. And based on that, I ask Your Honor to find the defendant guilty of both counts. Thank you.
Mr. Koch.
Yes, Your Honor. And Your Honor, for my closing statements, this is a unique bench trial, situation where I don't need to tell this court about the law, what to look at, but what I want to focus in on is the element of driving or actual physical control. That's what I want to focus my closing arguments on. And we briefly spoke about the inoperability defense. And with that defense, an individual, let me phrase that, it cannot satisfy the drove or actual physical control element if an individual is only, through the evidence, in physical control of an inoperable vehicle. And clearly, Corporal Montgomery's State's Exhibit 5, Picture 36, shows all the totaled cars. We have multiple images, but clearly that vehicle is inoperable. And I'll just briefly go through what Mr. Montgomery said about that. And he was a THI, traffic homicide investigator on scene. He stated front bumper was twisted, passenger wheel, the front passenger folded underneath itself, which enables it to not move anymore. Steering wheel airbag, passenger glove box airbag, fluid underneath the engine compartment. Corporal Montgomery stated that he believed that was radiator fluid, but that's an inoperable vehicle, that was not going to move. And physical control of an inoperable vehicle will not satisfy that element. And we saw body cam of Mr. Rase sitting in that vehicle. But because it's inoperable, we need to look at the evidence and the lack of evidence of who drove that vehicle during impact, during the crash surrounding that, Your Honor. And I'd like to first, kind of the order they were brought to court. Mercedes Claiborne, the civilian witness. She was one of the first to arrive. She stated very dark, quotes, only approached the white car, never approached the truck. The furthest she got to the truck was across the street, she testified. She testified that the passenger door was pinned, and of course that's undisputed. We saw multiple pictures of that door being cut off and it actually off that vehicle. So Ms. Claiborne, and as I stated, physical control cannot satisfy that element. What evidence did she bring us that Mr. Rase drove? She observed Mr. Rase being removed from the driver's side vehicle, of course after the crash, and with a pinned passenger side. But she could not verify who else was in that vehicle, how many people were in that vehicle. She could not see in it, and the whole nighttime, she said very dark multiple times. So seeing an individual being removed from the driver's side of a vehicle, passenger side, unable to open, don't know how many people in the vehicle, that does not satisfy drove that vehicle beyond a reasonable doubt. So I'd like to move next to Mr. Richard Culla. He was at the intersection, the four-way stop. He saw the crash but did not see who was driving. It was a blur. Unfortunately, he left to do a Chipotle drop-off order, and by the time he returned, he said what he believed to be Mr. Rase, so he's kind of unsure, but who he thought was Mr. Rase was already on a gurney being transported. So Mr. Richard Culla cannot satisfy that drove element. Now let's focus on the competent and complete investigation. Ms. Jasmine Stott. When she arrived, she immediately went to the truck, and we get a unique scenario of seeing the scene when she arrived. When law enforcement arrived, this was not in a abandoned warehouse or a cornfield in Iowa. There was, she stated, at least 7 civilians on scene, and through her body camera, I'm going to say around 5 were standing right by the open driver's side door. So when Jasmine Stott arrives on scene, of course the vehicle is inoperable, so now we got to see what kind of evidence we have for driving. She sees at least 7 civilians on scene. The driver's side door is open. I have at least 5 civilians standing right by the driver's side. There's 2 individuals in the truck. Now, the statements that she provided the I'm sorry. Nothing, no spontaneous, because I did make an objection during Acts report privilege, so she was very limited on her discussions, but I'm sorry. This is a lot of reasonable doubt that is not, I drove this vehicle in this accident. I'm at fault at this accident. There was none of that. So Ms. Jasmine Stott provided no evidence and kind of showed lack of evidence on that element of drove is not there under Mrs. Stott. Now moving to Mr. Benjamin Crawford, now lieutenant. He stated on the stand he approached the white Acura first, of course, the other vehicle. But watching his body cam, you can see that Ms. Stott is already at the truck. So, and I already told you my position on Ms. Stott and her, what she brought to the table on bringing element one, but Benjamin Crawford went to the white Acura first. He stated Officer Stott was with the truck, and then Lieutenant Crawford stated he had no direct contact with Mr. Rase. So through Lieutenant Crawford does not establish that drove element one. Moving on to Mr. Corporal Montgomery, of course, was a THI, traffic homicide investigator, gave expert testimony. I'd like to look at what he did not bring, the lack of evidence. Not once did he state Mr. Rase was the driver of the truck during the crash. Or if he gave us no testimony, Corporal Montgomery, on the, now he gave us after the fact, photos, there are no skid marks, there are scrapings, but no direct contact with my client. He even stated on the stand, this is Corporal Montgomery, EMS had already transported everyone, all but Mr. Thomas. That's what he stated. So the drive element cannot be established through Corporal Montgomery. Samantha McClellan testified. She was the general manager. She said she wasn't present that day, so of course there cannot establish that drove element. Miss Ann Grady and John Welcher, they gave us, or through them, we have the whiskey bar surveillance, and that's the 8:55:46 minute marker. That was the last, and of course, if that time is accurate, that is the last time we see Mr. Rase in that vehicle, or driving that vehicle, Your Honor, beyond a reasonable doubt driving. But it's interesting, Mr. Welcher testified that when he spoke to Mr. LeBlanc that evening, Mr. LeBlanc informed John Welcher, the bartender, that he had the keys to the truck, that it was his intention to drive, because Mr. Welcher kind of gave that warning after they're cut off, don't let that man drive, don't let Mr. Rase drive. And then Miss Morgan Mooney, she had a full interview post Miranda on body cam. Of course, it wasn't her body cam, but it was on video. I put forth to this court, it was not clear. I mean, we got the more I'm sorries, but not beyond a reasonable doubt that Mr. Rase drove. And then when Mr. LeBlanc testified, I did ask him about Mr. Welcher, the bartender. Did he remember? But he did not remember anything with Mr. Welcher informing him of driving or having the keys. But I did ask him about, hey, between 0 through 10, how were you before that accident? Because I asked him, were any stops made? Because I know this court is having trouble with that video, and I am too. That 8:55:46, we saw video of that vehicle in motion with my client driving. And I asked Mr. LeBlanc, after you left, did you stop anywhere? He said he did not recall, Your Honor. That's why I also asked at that time, because he did testify for consuming alcohol, what was his level? I asked between 0 and 10, 0 being sober, 10 being blackout. He said he was an 8, and he does not recall. We did see pictures of debris everywhere at that crash site. Cigarettes, beer cans, coolers. I don't know when those cigarettes were bought. I know Mr. LeBlanc, in one of the videos we saw, was smoking. But I'm pushing for that the inoperability, because of the nature of that vehicle, that we saw video, still photos of my client inside physical control of an inoperable vehicle. But beyond a reasonable doubt, there is no evidence that he drove, Your Honor. And that's respectfully being my argument, Your Honor.
Rebuttal?
And just briefly, Your Honor. When we have typical jury instructions with the jury, one of my favorite jury instructions to point out to the jury is when considering a verdict in this case, looking at the elements, one of the things we get to argue is that the trier of fact gets to use their common sense. And common sense includes looking at the totality of the circumstances in this case. We have Mr. LeBlanc's firsthand testimony saying just prior to the crash, he was in the passenger seat, Racer was driving, he was driving erratically. After the crash, he doesn't remember anything because he was unconscious. That's pretty strong evidence coming from a firsthand witness that's sitting probably less than 4 feet from Mr. Racer. The totality of the circumstances that show Mr. Racer driving from every other bar prior to this crash, leaving the whiskey barn in the driver's side of his own truck is very, very strong evidence that circumstantially we can infer that he was driving. We also heard Ms. Claiborne, even though she wasn't standing at the driver's seat on the scene of the crash, she said from when the moment she arrived at the scene, she saw nobody else coming in and out of that truck. She only saw the person who was sitting there, which she identified to be Mr. Racer, be in that passenger seat. And she also testified she got on scene very quickly. So based upon the totality of the circumstances and the common sense that we do get to consider when considering if the elements have been satisfied, the state would just ask the court to consider all of the physical evidence, the circumstantial evidence, and the testimony that's been presented and find the defendant guilty as charged. Thank you.
I'm going to take a brief recess to consider my judgment, and then we'll be back in just a bit. Madam Clerk, I'd like to have the evidence pause.
But they wanted to see, sure, that's all I was
Board is back in session.
At the lectern, please.
Mr. Rase, come, lectern.
All right. I find the defendant Benjamin David Razor guilty of driving under the influence. Manslaughter is charged in the information. And I find the defendant Benjamin David Razor guilty of driving under the influence, causing or contributing, causing seriously bodily injury as charged in the information.
Yes, Your Honor. I would request, speaking with Mr. Middleton, if we can set off sentencing. My intention was to move forward, but clearly from this morning, things have changed. I'm asking we get and if Mr. Middleton, if the judge gives us some dates, I'll let you address the court in regards to his schedule, Your Honor.
Yes, Your Honor, and I'm not going to delay, Your Honor, I'm just going to I think it would be appropriate to do a mitigation argument. I'm not going to present, if the mitigation's not there, I'm not going to present anything that would not be considered by the court in earnest and would not be any departure evidence. But I need a little time to speak with him. I have not spoken with him but one time on a jail monitored phone call. And of course, I couldn't get into the facts of the case, but I think the best procedural posture that we're in due to where we are would be a short continuance for a sentencing to allow me time to get with some dual diagnosis providers and try to put together something that's appropriate and in good faith before Your Honor prior to you sentencing the defendant. That's what I would ask to do. But I'm not, I can be ready within 30 days, maybe even sooner. I just need to get with at least one provider so I can get a nice idea of where we are in regards to this case and any mitigation possibility.
I think we're looking probably at September, excuse me. We got August 20, right, Madam Clerk?
Yes, Your Honor.
And then after that, we're going to be September 24. So it'd be
Your Honor, let's not delay it that long. Let's do it on August 20th. I need to, in good faith, expedite. I'll provide quality legal representation, but I would rather not do that to either the state or the court to push it back to any September date. If we could do it at an August date, the August 20th date, which should be sufficient if the court will allow it.
All right. Yes, sir. And if it looks like you're running up against time to get your expert in, then just consult with the state and I'll be happy to move it on. There's no reason to show up on the 20th only to say, I haven't been able to get it done. Just
and Your Honor, I have
with the state, and if we got to move it, we'll move it. I'd rather you have the time you need to be sure you can adequately present what you need, and don't have to just come here and check the box to say we need another date. Work in advance and be proactive about it.
No, I'm going to do so, Your Honor. I want both the state and the court to know I am that way, and I'm going to make sure I get that eval set up. I'll make sure the practitioner have a great relationship with a dual diagnostic psychiatric MP locally here in town with DNA Psych Elite in Tallahassee. So I'm going to get that going right away, Your Honor. I should have that report back within 2 weeks, and that'll give me enough time to review the report, speak with my client, and develop my argument for any discretionary departure that Your Honor may have.
Okay, so that would be 8:20 at 2 o'clock.
Thank you, Your Honor.
All right, that's Central Time, don't get confused.
I don't.
I know you're the lesser part of Florida there in the Eastern Time Zone.
That's true. That's true.
Mr. Koch.
Judge, for the PD's office, would you require us to follow up an order or for us to be officially relieved moving this point forward, or how would you like us to?
I think,
Your Honor, I did file the notice, and I'd request, or attendance too, if you could go ahead and remove the PD. He's done his job today, and any least amount of work for him moving forward, I I would also concur with
What I
him.
prefer to do is let's wrap all of this up. Be sure you've got all your strings tied up. Be sure you've handed off everything you need to do to Mr. Middleton. And when you let Mrs. Natale know that's squared away, then I'll go ahead and enter that order. You understand where I'm coming from, because once I enter that order, you're off the docket, right? And you can't see anything anymore. And if there's anything else you need to do to pass off, then you're going to be shut out, right?
Yes.
So take the time, since we're right here at the end of trial, we just got finished, take the time you need to engage with Mr. Middleton. If you need to grab anything and get it to him before that happens, you see where I'm coming from? Is that okay with you, Mr. Middleton? You understand what I'm saying?
I do, Your Honor. I do. I understand.
So you just let Ms. Natale know when you've completed what you need to do to pass things off to Mr. Middleton, and when you tell her that, then you submit your order and I'll sign it.
Understood, Judge.
All right?
Thank you.
Okay.
PSI, Mr. Middleton, Mr. Koch?
I'll let Mr. Middleton, and just for his knowledge, I believe there was a PSI back in the 2011 case or 2013 case, Mr. Middleton. That was the last PSI and the only PSI ever conducted. So I'll let you advise the court if you want to request one in this case.
Your Honor, particularly as it is juxtaposed to this case, I would not in this case. I would prefer to go at me and you, Your Honor, so that's my preference today.
And I'm sorry, you went digital on me real quick. I didn't hear if it's a yes or a no.
I said, Your Honor, I would decline at this time. I'd rather go it alone with you, Your Honor, than request a PSI.
Okay, all right, so no PSIs ordered.
Your Honor.
Yes.
That's correct.
If Mr. LeBlanc wishes to be present for sentencing, may he appear over Zoom?
Mr. Middleton, do you have any objection if Mr. LeBlanc, the victim, is appearing by Zoom for the sentencing?
Where does Mr. LeBlanc reside again? I apologize. I believe it's out of state.
In North Carolina.
That's correct.
Your Honor, I am not going to require Mr. LeBlanc to come all the way back down here
And
for
also,
that. I think Zoom is fine.
and Mr. Thomas's family as well, if they wish to be present over Zoom.
Okay.
Is
And
there
then
any
they're also
objection
out of
to that?
state?
Yeah, it's Mr.
They are.
I believe,
They live in Georgia.
right. Is that
Okay.
okay, Mr. Middleton?
I don't object to that. That's reasonable, and I don't mind that. That's practical.
All right. And Madam Clerk, if you'll be sure that's properly noted on the minutes, unless someone wishes to do a separate order indicating that. You satisfied with it being on the minutes, Mr. Middleton, or you want a separate order regarding the vote?
No, for the record, Your Honor, I typically do not object to a witness appearing, especially for sentencing, remotely. So for the record, orally, and I do not object to any witness the state wants to present that is not local to Okaloosa County to appear and offer statements by Zoom, and I'm fine with that.
Okay, all right, very good. Anything further? I'd ask Mr. Koch, Ms. Glisson, y'all approach. Be sure that I didn't keep any of the evidence that's in the bin. Be sure everything's present, nothing extraneous before Madam Clerk closes out the custody evidence.
Yes, Judge.
Okay.
Thank you.
And, Your Honor, I would just state to my client, I will be speaking with him very soon, probably today at some point, electronically. So just so he knows that. So, Mr. Benjamin, I will be speaking with you today at some point in time, okay?
Oh, yes, I'm sorry. Y'all could be seated. I apologize. Sorry. Sure. Is all the evidence present? Okay. All right. Unless there's anything further, we'll be adjourned.
Thank you, Your Honor.
Thank you, Mr. Middleton. Good day. Thank you, Mr.
Thank you, Your Honor. Thank you, State.
Gomez. Good day.
And thank you, Mr. Cox.